Hi, all. It's Allison Mata here, actually getting a last-minute update from Bob just to clarify my understanding of his notes. All right. I did. Well, I read the okay, officially on. Good afternoon, everybody. So hold on one sec. I don't know what's going on here. So as you know, Bob is in the courtroom, and he gave me his notes from the morning at the morning break, and again, um, at the just now. So how's my sound, guys? Do I sound all right? Because I'm having trouble hearing myself. Sounds great. Okay. All right. So let's move on. All right. So everyone, most of you probably know, but I'll just say so Bob is boots on the ground in the Carroll County Courthouse for the Richard Allen trial, Indiana versus Richard Allen. Today, the state turned its focus to introducing evidence against Richard Allen. As far as I see it, this is my opinion personally. I didn't think that any of the witnesses who got on and testified about seeing Bridge Guy or somebody out on the bridge, none of those people described Richard Allen in any way, shape, or form. So to me, this is the first actual headway that the state is attempting to make, and let's see what you think about if it's actual headway or what. But it is their they did introduce evidence that is circumstantially could be damning. Bob just gave me some additional information, so I don't know. We'll have to see. Like I said, I'll tell you guys what it is, and then we'll talk about it some. I'll give a chance for some more people to come in here. This afternoon, Bob let me know that there is, I think it's a Mendez resentencing. Bob let me know, and Dizzy and Mandian let me know, I think. Yes, both of you. Oh, so Dizzy said it's a presser regarding resentencing, and Bob said, oh no, Bob said the same thing. Okay, sorry guys. Mendez presser. So we are also going to be back on a separate stream at 3 o'clock Central Standard Time. We're working on getting that up and out to you guys. Let me see. While we wait for some more people to pile in, we can say hi to Dawn Burke. She already gifted 10 Defense Diary podcast memberships. Thank you, Dawn. And Dawn herself has been a member for 11 months. Thank you guys for all you do. Thank you, Dawn. I appreciate it. See a lot of the usual suspects in here. Um, let me just see what we got. And you guys, if you've got a question, a lot of you do it like this, especially to our uh, members. Put a Q in front of it so that it's recognized as um, opposed to just a comment. And same thing for the super stickers because I like to hit the questions first and then thank everybody for their comments. But either way, anybody who sends a super sticker is absolutely positively going to get addressed. And don't forget to like because got to get these live sessions out there for the world to see and know. All right, so let's just get to it. So there was some circumstantial evidence today. Um, as far as I see it, we heard from in the morning. We heard from people who handled the tip line and um, interviewed Richard Allen, Dan Dulan, who interviewed Richard Allen, and we had some jury questions again. And then in the afternoon, I haven't even looked at the afternoon yet. Oh, I guess they resumed on the redirect, had some more jury questions. Steve Mullen back on the stand again. Um, so let's start with the morning. All right. So well, let's just because I told people I'd answer a question, so let me just here's a cue. I'll just do this real quick, and then I'll go. Why didn't the state ask any of yesterday's witnesses if they could identify Bridge Guy or if they saw Bridge Guy in the courtroom? I'm assuming because they either were gonna say they didn't know or they weren't sure. I mean, they didn't describe Richard Allen. So that's got to be the answer. But then it also begs the question, why didn't the defense? Now, I don't know everyone that they did a deposition of, but I do remember at least some of them were deposed. So I don't know, but they are recalling some of these witnesses. It's my understanding. So we will have to. All right, sorry, I'm back. Sometimes StreamYard does this thing where if I click the mouse a certain way, it does like it thinks that I want back or out, and it did that. So, um, and thank you, Christy, for becoming a new member. So the first witness this morning, day 6, Kathy Shank. Now she is the person who this is what Bob wrote, lost Rick's statement. All right, so she lives in Delphi. She attended Purdue University. She worked for the Department of Child Services until 2011, and she became involved in this case back in 2017 after she saw the first press conference. She called the former prosecutor, uh, Robert I don't know, is it Ives or Eves? I guess it's Ives, and offered to help. So March 1st, she signed a non-disclosure and she worked the tip line. 50 or so officers were working on the case. That was an estimate. She took on additional duties at some time. She was given banker boxes full of reports. She was tasked or she took reports and began organizing the files into 5 different filing cabinets. And then most of what she says next is all just kind of getting out that she wasn't reading them. She was just supposed to enter certain information in. She was supposed to get it um, into categories. And then when leads came in, okay, so I'm sorry, she was instructed to put the narrative summaries into a database. So when leads came in, they were entered into a database. She was also tasked with putting the tip line into the database, which kind of seems the same. All right. So she would receive the tips via email. Then the whole operation was moved over to the city building. And over time, as the leads uh, as less leads were being generated, she started working on tips. So there was like a filing cabinet of info in September of 2020. She began scanning all the documents from the filing cabinet into the database. This took 2 years to create this database. So in Oh, and there were over 14,000 tips. She worked from 12 to 5 or 6 p.m. When they moved from the city building, she found a file box for later review. She observed that the box had handwritten tip numbers. She had not entered any handwritten tips into the database. Hold on one second, guys. Stand by. All right. Sorry about that. So it was, again, that took 2 years. She found this box when they moved from the city building, and in that right, so she said she had not entered handwritten tips or leads that occurred prior to her starting working in 3/1, that on March 1st, that's what she said. She found a lead sheet, Richard Allen, and I think it's Whiting. I think they say it somewhere else, but I'm sure you guys all know maybe it's Whiteman. Let me grab my glasses. Eh, okay. Yep, Whiteman had been out to the trails from 1:30 to 3. She com she compared the lead sheet. She did something with the lead sheet, uh, or did sh I don't know, sorry guys, I don't know what that says. She Okay, so then Bob writes, "She just testified she was working in February!" Exclamation point, exclamation point, because remember, she says, "Well, I hadn't entered any leads, that were before I started working in March." So then Bob's right. She just testified that she started in February. Diener had to correct her that she didn't start working until March 1st, because obviously otherwise, how'd she miss it? Um, a narrative had been entered into the database regarding a Richard Allen. The tip she found had a green mark in the file, which meant cleared. She was not reading the contents of files yet at this point. She she discovered the Richard Allen Whiteman filed September 21st of 2022, and she remembered that date because it was her deceased husband's birthday. Then they entered this three-page document. Richard Allen's statement to Dan Dulan was published. So then Andy cross-examined her. You don't have any idea if the report on page 3 contains any mistakes. Do you know? You don't know who made the mistake of placing Richard Allen Whiteman on the file, or do you? No, I don't. Um, did you create that file for Dulan's report? No, I didn't. What's Orion? It's a database. All the tips came in through emails. And they had like a way that they did it. The tips were entered. If it generated a lead, it would be entered and assigned. A person of interest would be spoken to, and a narrative entered into the database. That's how they did that. There were no other tips regarding Richard Allen to her knowledge, or anybody by the name of Richard Allen Whiteman. Um, she recalled that a female witness had seen a man on the bridge during some time frame. She thought that witness should be spoken to. She said that there was officers from Delphi, Indiana State Police, the FBI that were all involved. A lot of people, uh, a lot of tips came in that said, "Oh, this looks like my neighbor," or "This guy sounds like a friend of mine." And in September of so the defense asks, in September of 2022, like while this was found, Tony Liggett was running for sheriff. Objection sustained. Uh you know, and then it went into redirect. You didn't start entering tips in the database until the city building, and there were a lot of tips entered before she started. She said, "Oh, yes." And you didn't read all of them, no. On Recross, as far as you know, Richard Allen gave a statement in aid of the investigation. I meant to ask Bob about that. I'm assuming it was, like, objected to because there's no answer. So then you have a jury question. How did you determine it was incorrect? Meaning, like, Richard Allen Whiteman. And she just said, "Well, I know there's a Whiteman Drive in Delphi." So she put it together that Richard Allen must live on Whiteman Drive. So, and right there, there's nothing new, obviously, but it does explain sort of how the tip was found and uh, puts out their narrative on that issue. But then we get to Dan Dulan, all right, and he was a nature resource officer. So he came on February 16th. He came on February 16th to assist in the investigation. On the 18th, he began following up on leads. Every morning, lead sheets were processed and uh, and put out. Lead sheets would contain the name of the individual, the address, the phone number, and a short narrative. Some were self-reporting leads. Some were people calling in tips about other people. Um, then they sort of give the way their tip sheet would be. It starts with who was reporting, how they contacted them by phone, in person, a short narrative, and a status or disposition. So for Richard Allen, it said the person reporting was Richard Allen Whiteman. Um, and then it gave contact information, what to inquire about. He called Richard Allen on 2/18. And they asked to come to his house, he denied that. He asked him to come to the police station, he denied that. He said he wanted to meet at a grocery store. Now on Cross, the defense establishes that he was on his way to the grocery store. Um, so anyway, they had a conversation, and so now this is on the 18th. They had a conversation and he was on the trail between 1 and 3 o'clock is what it said on the lead, but when they met in person and spoke, he said 1 to 1:30 to 3:30. So now to me, this is definitely a problem. You've got it's only 5 days later. Like I had always thought, well, I don't know when did he make this statement? This could just be like I was out there somewhere between 1:30 and 3:30, not like 1:30 to 3:30, you know. And maybe it still could be. However, with it being that close in time, and this is pure speculation on my part, obviously, but you would think that when someone watches the news or hears about this, and I'm going to assume that everybody that lived out there heard it that day. So let's just assume for the purposes of this that he was found out that the girls were missing on the very same day. He obviously knows he was there. I would think that would make him right then and there think about the times that he was there. So that's why I think with it being this close in time, maybe he was saying he was there from 1:30 to 3:30, which is problematic because the defense is now saying 12 to 1:30. On the flip side, think about when we were like during COVID and we all had nowhere to go and nothing to do. You could have probably asked me the next day, like, when did you guys go on that hike with the dog and the kids to this place? And with no like kids coming home or like times that matter, I would just have to guess, like, around about when it was. I don't know. Was Richard Allen working? Was he, was there something timing-wise that would, let him make him remember, when he got there or what he was doing and how long he was there? So it could just be that he said, "I was somewhere there between 1:30 and 3:30," or it could be, "I was I was there from 1:33," and then he actually corrects it, 1:30 to 3:30. But I think either way it's taken, it's a little something for the jury to see as, all right, that's different than what he's saying it now. He said it close to time. But yes, we don't have his cell data yet. I don't know if we will because they said they didn't find that cell, and I'm not sure if they could go back that far. I don't know what the geofencing said. Like I, My guess is as good as your guys, but, it's something that the jury could say, "All right, um, I find that to be suspicious," or "I'm tucking that away." So, let's get back to it, if I did with those glasses. Okay. So, he had a conversation with him, and that's where he said it was like 1:30 to 3:30, that he saw 3 girls, that he parked at the Farm Bureau parking lot, and that he walked from the vehicle to the Freedom Bridge, to the trails, to the High Bridge. So, this guy, Dulan, I think it was, right? Yeah, Dulan, he was taking notes, handwritten notes on the back of the lead sheet. There was no audio, video recording. There was nothing to he had nothing to voice record with him. This was Bob wrote, "First tip interview." So that to me means this was this guy's very first interview. He did take additional information. He got the phone information and the MEID and other identifying factors. Then he ran his driver's license, and this went in as Exhibit 230. He created a report with a picture, a driving license, contact, and his notes. So I kinda highlighted that to think, so all his picture and everything was already in there. I don't could that have influenced something, but did no one really see it or did they? Who knows? But Bridge Guy came out long before, um, this his statement was found, and I'll tell you, it would seem like a really stretch if you're trying to say they waited and they were they were, like, starting to to think about Richard Allen back then and then waited 5 years, but in any event, um, and so he did this within an hour of the interview, did all of that, and then they entered the driver's license into evidence. He asked if he recalled the name Richard Allen gave him, he said he didn't. Um, when you spoke to Richard Allen, did he say he saw 3 girls? And did he say they were walking which direction they were walking? And I'm sure he gave the answer, which Bob knows from heart. I'm sure you guys do too, and didn't write it in here. And he said, "Did he see anyone else?" And he said, "I don't know." Or maybe that was the answer that he gave. "I don't know because I was looking at the stock ticker." He submitted the lead sheet in person over to the command center, and he did not follow up on it. Then there was something about an updated lead sheet. Bob will have to get back to you on that too. It was Exhibit 232. It just says that had been entered into the Orion database, someone had typed his Word document narrative into the database. Or maybe that wasn't my question. Does the updating lead sheet match your Word document? So he took the notes his handwritten notes, created a Word document, and they're going to get to this here more. And then he threw away the handwritten notes. Someone then took that Word document that he typed up that he handed over to the command center with the driver's license and all of that, and somebody entered it into the database. So on September 22nd, Mullen called and asked him if he remembered talking to Richard Allen. He said vaguely. Then he went and looked at the binder to refresh his recollection, brought his documents to command center. Um, he did more research um, into Richard Allen, looked at his fishing and hunting license, name, address, email, searched Richard Allen's stuff for all of that. The fishing license contains his name, address, height, weight, sorry, and phone number. They asked what credit card he used, IP address, and did he make any changes to his physical profile? And this is why I wrote in that uh in my post about this that some damning evidence came out today. So the answer was while reviewing the fishing license, Allen had changed his height from 5'4" to 5'6" in April of 2017, and then he also changed his weight. I mean, his yeah, his weight. So that to me is obviously very highly problematic. That's consciousness of guilt evidence. It's circumstantial, but it's definitely something, and it's starting to paint a picture. It's the first time the state has put in actual evidence that starts to show some sort of consciousness of guilt. Um, you know, but I just spoke to Bob about the cross and the redirect that might have changed. So it might not be as damning as I think. Well, like I said, I'll see what you guys think about it after we get through this. So then the McClelland asked, "It's not uncommon for people to change their height and weight." No, it's not. And then it says thought it was. I don't know if that was Bob. And I think that that's because I'm not sure why they asked that question. And then Rosie did the cross. Um, and he clarified that Alan made the call to speak with an officer. The lead sheet didn't, and the guy he answered that the lead sheet didn't indicate if it was an email or a phone call. He gave his correct phone number. Yes, he met with Alan within minutes. Yes. So that to me changes the whole, he didn't want them to come to the house. He didn't want to go to the police station. It sounds like the officer, if this is an officer, I mean, it must be an officer, um, wanted to meet with him right away. So he says, I'm on my way to the market. I'll meet you there. And then he asked him, Rick said he was on his way to the grocery store. And the answer was, I do not recall. Some people don't feel comfortable with law enforcement coming to their house, was the next question. Yes. All right. So now they start talking about the 1 to 3 and 1:30 to 3:30 lead sheet. Um, and he said, those are just blocks of time. He didn't tell you what time he got there. The report says he was on the trail between 1:30 and 3:30. And this has the answer as doesn't say when he got to the trail. Nothing on that day you met with him struck you as unusual. No. Nothing stood out to you that made you want to note something. No. And then he confirms you threw your handwritten notes out after you created the Word document. Yes. Then the next question was, your hand notes would have been the best evidence. And then there was an objection that was sustained. I don't quite know why, because it is, and it's a normal question. Then he asks about his handwriting notes would be the most accurate, and there was an objection, and it was sustained again. Um, you don't have an independent recollection of meeting Richard Allen, do you? And he answered, after I reviewed the binder, I remembered the stock ticker. And then this guy was deposed because he was impeached with his deposition where he said he did not recall the meeting. Um, Richard Allen Whiteman was listed on that lead sheet, and he said, it's not my mistake. And the question was, you're not suggesting he gave you an alias, are you? Objection, speculation, answer sustained. Um, I didn't hear it go down. It seems they should have asked, not your mistake, maybe whose mistake was it then? Or do you know whose mistake it was? But then Rosie pointed out that how well, you initially testified he changed his height and weight. Oh, no, I'm sorry. Then Rosie asked another question or argued to the judge that he testified that he initially changed his weight and height. It's relevant, with some other kind of objection sustained. Um, you didn't ask what he was wearing that day. No. To me, that was important because if he had said back on the 18th, 5 days later, "Oh, I was wearing a blue jacket," but, describing his clothes, then I think that's likely what he was wearing. But if it wasn't until, 4 years later, then who knows what he was wearing, and the state could have just asked him, "Could you have been wearing a blue jacket?" "Sure, I could have." "Could you have been wearing?" "Sure, I could have." That kinda thing. So, he asked him a question about the old Farm Bureau versus the CPS building, and, he testified that they did not look at a map, so they didn't really confirm whether sounds to me what he's getting to is that they didn't confirm whether when Richard Allen said the old farm building, if that is in fact the CPS building. Then they go back to the fishing license. In the past, the fishing license stated his height was 5'6" in prior years. And the answer was the system header changes the height and weight to the most recent entered height and weight. If you print out a list of all his licenses over the years, those would all list and reflect the most recent height and weight. So then he asks him again, so the system changes all the historic height and weights in the system, and you can no longer see what the listed height and weight was in the past? And this guy says, "No." Um, and then he's asked, he could have listed himself in past years as 5'6", and you wouldn't know that. Answer, correct. So now this is what Bob was just telling me. He said that he couldn't get everything into his writing, but that because I was like, I didn't understand that question. So did he or did he not list himself? And do they know that he actually changed it on April, whatever it was, 12th or just April of 2017. What Bob said to me was that's when he updated his license. So, and it seemed to me that they could not tell that he changed it. It's just that on that license, it was listed as 5'6". But Bob said in depositions, Rossi, like on cross-examination, Rossi got into how during the depositions, he showed this witness proof that in prior years, it already said 5'6". So that's why I'm saying maybe what I thought was, damning piece of circumstantial evidence, at least something that could be considered consciousness of guilt, might just be nothing. Because if he already had it listed as 5'6" in prior years, then that means nothing. I think that should have, if that is the case, that surely should have warranted an objection, a sidebar, and something to be done and for the state to have presented this witness as he changed um, his height and weight in April of 2017. If that's not what really happened, and the defense really has proof that, and maybe he's got the old license, like the old physical license, then they should have done something a little bit stronger, but maybe they're just waiting and biding their time, and when they put on I was gonna say his wife, but I wonder if that would then be hearsay for her to, um get in his well, I mean, she might be able to get them in as this is his, I ordered them both, these came in the mail, and then maybe they get it in, I don't know. So, if the defense has evidence that Richard Allen listed his height as 5'6" prior to April 17th, then all of this means absolutely nothing, and then the state is again caught attempting to mislead the jury. It's one of those 2 things. Either it's consciousness of guilt evidence, looks really bad for Richard Allen if he changed his height in April of 2017, or it looks like the state is again trying to pull the wool over the jury's eyes if in fact there is evidence that he already had listed himself as 5 5'6" prior. And I'm like, I'm not reading all the chat. So, look, guys, sometimes I'm going to think that there's something damning that you guys don't think is damning. But, I'm just going to give my honest opinion of the evidence as I'm hearing it, same as you guys are hearing it. So they went on a little more. Again, the last thing was he could have listed himself in past years as 5'6", and you wouldn't know it. Answer, correct. Um, Then he asked him, "You spend a lot of time in the woods?" "Yes." "You're familiar with the bridge and the area?" "Yes." Um, "Have you noticed deer blinds in the woods?" "Yes." "It's not uncommon to have spent casings in the woods." Answer: It's not uncommon. It's not uncommon for hunters to carry a handgun while hunting. No, it's not. Smith& and Wesson is very common ammunition. Yes. So that to me was all outside of the scope of the direct. So I wonder why maybe the state was asleep right there. 'Cause I don't know why they let it in. And then McClellan does redirect. The system shows identity information of the person who purchased the fishing license, the email, the credit card, and the IP address. Yes. It says Richard Allen's credit card was used to purchase a license for Rick and Kathy. When you met Allen, did you go through his phone? No, he gave me the MEID. And then again on Recross, Rosie asks, the system is only showing the last 2 years, 2016 and 2017, not the whole historical license history. Question, answer, yes. So I still can't tell from that if he's saying that in 15 it was 5.6, and then in 16 it was 5.4, and then in 17 he went back and put it to 5.6. I mean, maybe an explanation is that, like, in 15, I did it, so it was 5.4. In 16, my wife did it, and I put 5.6, my wife put 5.4, and in 17, when I see it's 5.4 again, I put it back to 5.6 because, he's short, and, you know, short people like to make themselves um, a little bit taller. So Sleuthy is asking, we want whatever. Everybody wants to know why I think it was damning. It's called consciousness of guilt. If he has always listed his fishing license as 5.4, and this 1 year, 2 months after there's all of this happens, he makes his height taller, the state can argue that's consciousness of guilt. That you're trying to, you know, make yourself appear taller for people that are, like, just going through things like that. Well, let's just check pull hunting licenses again. Let's see who meets this description. So, if Richard Allen was the guy who actually did it, and he's assuming that witnesses saw him and are describing him as 5'4", it could be viewed as him making himself look older to take suspicion off of him. Obviously, he's not changing. I didn't hear anything about him changing his driver's license, things like that. But it's something. So that's why I think that it could be damning. It's to me, it's the first piece of evidence, no matter how hard it hits or doesn't hit, that the state even put in, that is even starting to focus on Richard Allen. Nothing else to date focuses on Richard Allen as from what I see. I don't see anything that does, you know. But yeah, I mean that's something, as is if he said that he was there from 1:30 to 3:30 and the jury accepts that as that was him giving his time frame of when he was there, and not just like I've said in the past, well, it could just be him saying, I was there somewhere around, 1:30 to 3:30, somewhere in that time frame. That is problematic for the defense. We've got to look at things objectively, and if you guys can't do that with, that doesn't mean you can't have a different opinion. Go ahead and have one. But um so Evan's asking, I'm confused, Allie. Did Cross reveal that to be true? I cannot tell. It sounds like Cross said in prior years he had also listed himself as 5'4". And when I spoke to Bob on the phone, he said that during deposition, that there was part of this cross-examination was that during this witness's deposition, the defense showed them proof or state something that indicated he had done it in years prior. So again, if that is the case, then that's why I just said this is all meaningless if that's the case. But there sure as shit should have been some sort of really serious objection if he didn't actually change it on the 16th. And then again, and you guys all have to, you know, follow up with Bob to get some more on this. He'll circle back to this stuff when he gives you guys his update. This questioning, this last questioning about the system only showing the last 2 years, 16 and 17, and not the whole historical license history. What I'm thinking there is it's possible, like I just said, if in prior years it said 5-4. Hold on, stand by, guys. Give me a second. Chat and yell amongst yourselves. All right, I'm back. I'm back. All right, I guess I'll look at some of your comments. So sweet dude Shibby says a guilty person would change lots more than 1 inch on a fishing license. I agree. I just said that. I mean, did he change his driver's license? Did he change this? Did he change that? And all I'm saying is prior to this, the state hadn't been focusing on really Richard Allen at all. And this is at least what they think is consciousness of guilt evidence, something to shade who he is. Is it that powerful? That's for you to decide. I'm just saying it's something that could be seen as damning. Although, if the facts are the way Bob sort of explained them to me and examination fleshed out, it could just be seen as the prosecution just tried to pull the wool over the jury's eyes yet again. But I agree, if somebody is trying to change, like, the sky's who they are, changing it on your fishing license is not very effective. I absolutely agree with that. But we're talking about what thought that might be putting in the jury, because the way the state presented it was he changed his um his height from 5'4" to 5'6". And again, even if he changed it, if what comes out later, based on this last question I was telling you about 16 to 17, is like, well, my wife did the applications in 16 and listed my height as 5'4". So in 17, I switched it back to 5'6", which is what it was in 14 when I did it, or in 15 when I did it. If they can show that every time Richard Allen applied for the license, he listed himself as 5'6", um, then it's uh, again, then it's something that just says to the jury, the state just tried to pull the wool over your eyes. And Golden asks, I'm gonna look right now if the driver's license um, listed his. I'm sure it was on there because they actually entered the driver's license. I just don't know if they told us what height was on the driver's license. Also, there was a jury question that I still have to get back to. All right. So it says that when he got back, he pulled the driver's license and he created a report. The driver's license was entered into evidence. So you'll have to ask Bob tonight if the driver's license accurately listed his um, height, or if he always listed it as 5'6" on everything. All right, jury question for this guy. The report you turned in included your printed out lead sheet question. I don't know the answer because Bob didn't write it. But I think he said if I go back to it's, like, actually in the notes because I think he did say it the first time. Um, and again, on cross, they did, you know, establish that he coulda listed himself as 5'6" in prior years, and this witness wouldn't know it. But he said he took his report. They made an updated lead sheet at some point. Yeah, it just says he created a report with the picture, the driver's license, the contact, and his notes. Um, so that was the juror question, but I don't know the answer, so Bob will have to get back to you guys. Or oh wait. So yeah, no, I don't have the answer. All right. And next was Steve Mullen. But let me see if you guys have questions up to now. Everybody's yelling at me about my opinion, it sounds like. Milan, 1885, just to thank you. Also, will Ives' subpoena to quash be approved? You know, if there's, I guess I should look and see if there are, motions that have come down. I don't know. I'll have to look because I don't know what the subpoena says yet. So, um, did they ever test the blood on the F? No, they did not. Wait, I take that back. I think they did swab it. So I think the answer might be yes. I don't know right now, but my recollection is that they did swab the tree. They just never took the F, but they did swab the tree. Um, and Emma wants to know, how is it possible they don't have his cell data? The witness said they contacted people based on it at the start of the investigation. So they did do the geofencing, and then they did contact people based off of geofencing. They also said that Richard Allen he doesn't have his phone from back in 2017, and it might be too much time has gone by to get that data from, location history data from, I think he was AT&T, or I don't know what he was actually. I'm thinking of the victim's phone was Libby's phone was AT&T, and T, and one of the witnesses was Verizon. I don't know what Richard Allen's was. Maybe someone in the chat does, but that many years later, I don't know that they could get it. And Dizzy sent me that motion, so I will go over that after we go over the next witness. Um, all right, so Michael wants to know, McClellan was doing the direct. Um, right. So if we're talking about this last witness, it was McClelland. The first witness, I think that was McClelland as well. Let me see. Bob didn't write it down, probably because he'll remember. But I know Dan Dulan was McClelland because it says McClelland redirect. And then we've got, but hi, Michael. Glad you can chat again. Dawn says, so RA spoke with Dan Dulan on the 18th. Yes. The photo of Bridge Guy was released on the 15th. I think that's, or the 17th. I'm sure someone knows in the chat, but all I know is that it was days later because I was sort of focused on the I was remembering the date of the video, the bridge guy video, and then Bob had to correct me. He was like, "No, that was days before." But yeah, I mean, he spoke to him quickly, and clearly this guy didn't think he looked particularly close to the person in the sketch if it was released, and I do think it was. Um, Sleuths investigate. So Alan's cell phone from 2000 may be missing, and Alan allegedly changed his height. So where is the damning factual evidence against RA? Again, all I'm saying is that, and I personally, I don't think the 2017 missing phone is damning at all. To me, it's like, because Bob was telling me he thought that might be a problem, and I'm like, I don't get it. Why? I mean, unless he's got every other phone and not the one on the 17th. And yeah, the image was released on the 15th. So I don't think that's damning. All I'm saying is until now, they haven't put on any evidence that focused on actually Richard Allen. All the other evidence was the girls' movements, what they did, who came, when they showed up, and random people out at the bridge seeing someone who looks nothing like, by their own description, nothing like, I mean, that first sketch does look something like Richard Allen, so that's not what I'm saying, but based on the person that everyone described, younger, big or muscular, curly hair, hair poking out. I mean, none of those were Richard Allen as far as I'm concerned. I don't think the jury took any of that to be evidence that against Richard Allen, especially because none of the people identified him. So, when I say that there's at today is the first day they started even presenting evidence about their case against Richard Allen. The this piece about changing their height, that was their way of presenting consciousness of guilt evidence. And I said it could be damning, but as we sort of fleshed out here, it might not be damning at all, and it might just be that the state's going to look like they were again trying to pull the wool over the jury's eyes. Who decided to mark his statement as cleared? We don't know yet, and I don't know if they will ever know. Evan, Allie, the defense is using it to ruin the state's credibility then, right? Well, the defense used it, I think, at in a deposition, these other, uh, years that Richard Allen had listed his weight as 5'4" to show that he's done this before. This is not new. This is not something that all of a sudden, April 17th, he changes his height. Um, so they would be when the defense if the defense puts in more evidence like that, it's whether or not the jury right now really thinks it's that compelling. I'm not saying all that. I'm just saying it's something. But if the state defense puts in evidence that the state knows that he had listed it on other years as 5'4", then again, it's going to look really bad for the prosecution. There's no evidence that they asked him for his phone and he refused. There's no evidence they ever asked him for anything and he refused. I don't know if that's something we're gonna hear. Um, Again, that I agree with you, Emma. Him not having a phone from 2017 is not sketchy at all. And, the other thing is if all of we download when you get a new phone, you download from a backup. You download from a backup. I had a client in, like, whose iCloud data from, I think, went back 7 years, 8 years, and we're talking long before this, and they were able to pull up location data from that backup of the iCloud still on a brand new phone. No, you've not been timed out again. Why? What are you talking about? Did something happen to Michael again? So I don't know. To me, it's nothing. I don't even see what they were trying to prove. Who saves their phones from 5 years ago? And maybe even if some people do, it's not. I don't find that to be. It's a red herring as far as I'm concerned. Did you say naughty words? Oh, Michael. Is there any way the Odin theory can be brought up? It's my understanding they filed a new motion. I don't know if that's something that Bob's already gone over with you guys, or if I should throw that in here now as well. And we still have Steve Mullen, the last witness, to get to. Um, oh, I'm sorry, but Taylor also asked what would open the door to it. I think it's just a matter of, like, the crime scene pictures, more of them, but I'm sure the judge has seen all of that. Um, Maybe testimony about it not being, odd, but I think it's more gonna have to be, like, new evidence of people demonstrating that something is more meaningful than what the judge thought it was. Um, so we'll have to see. So Spitfire says, "Have any of the witnesses testified that the person they saw on the bridge was noticeably short?" No, they have not. Um, Bridge guy was previously reported as being 5'10" or taller. Correct. So, well, right. Adding 2 inches would make him closer to bridge guy, but in theory, he doesn't know that. That's why I'm saying if he were the killer, if someone on the jury is assuming he is the killer, then the killer would assume people might have seen him, and they might describe that person as 5'4" if they saw him and it was him. So, changing it could be trying to shift, to take eyes off you, but again, it's just a fishing license, it's not all that compelling. I'm just saying, it's something that if the jurors, they might consider, or it might mean nothing. But yeah, I think so far everyone has testified he was taller. Someone stood up and was like shoulder length, and it sounds like we've gotten like 5'7s to 5'10, maybe even higher. So yeah, it's that's that. If Richard Allen was there from 12 to 1:30, he would have seen the 3 girls and Betsy Blair on the trails at that time. He didn't, and they didn't see him till after 1:30. Well, nobody saw Richard Allen. They saw either Bridge Guy or someone after 1:30. No one has said that they saw Richard Allen. So, um wait, sorry, you just put one up that I okay. Rosy colored glasses. Do you suppose defense didn't object and request a sidebar because the defense thought it would play like the state was trying to mislead the jury? I do. And maybe that's the same question that Evan was saying as well. So I apologize, Evan. But yeah, I think that rosy rosy colored glasses, I think that's a definite possibility because I would have been hopping up and down, but if they do have all their ducks in a row, they're just like, "All right, write your own, seal your own fate, mislead the jury as you will," because that does the more that they mislead the jury, it gives the defense more leeway to put in more evidence in their case in chief, and we know that they've got a ton of evidence, at least in their opinion, that shows state actors are lying. They're changing their stories, they're lying, people are sneaky and shady. So anytime that the prosecution wants to mislead this jury, rosy colored glasses is absolutely correct. The defense could just be giving them enough rope to hang themselves with what they're going to be able to now get in and during their case in chief. So the more lies the prosecution tells, okay, assuming they're lies, assuming that's what the defense is able to show or what the defense thinks they'll be able to show, then the more they're going to be able to put in evidence of those lies during their case in chief, assuming that the judge finds it to be something that's not collateral, meaning not important that they're not allowed to do it, and technically, you should impeach a witness while you have them on the stand, and you're not supposed to impeach a witness with collateral information, but this wouldn't be collateral. Sorry, my mind's sort of thinking the whole thing out evidentiary speaking, the evidentiary process, but yeah. Richard Allen said he parked at the farm building. The state has said that means the CPS building because there is no Farm Bureau Farm Bureau building. And then Rosie asked on cross, you didn't take out a map to determine what Richard Allen meant when he said Farm Bureau building. Lana, thank you. Could they not have the physical phone from 2000? Yes, that's Nike. Is that what that says? Or Nico? Nico? I believe so, I just don't know. I don't know, did they get their own experts? Did they pull from backups of iCloud? But if the state has other devices and those devices are, using an iCloud that was in place in 2016, 2015, yes, they could still have the data without the phone. That's why I'm saying, why the hell is the missing phone important? You don't need the phone to figure this stuff out. Um, so yeah. Keith, Allie, do you know if the defense can file a motion to have visibility of the juror questions that Gull did not allow? So the lawyers are both seeing those questions, and those questions will become part of the record, whether Gull allows the public to know or when she might allow the public to know or make that part of the public record. We will have to see. But I suspect, like, as intelligent as it seems this jury is with all their questions, and I really do believe they're paying close attention and asking great questions, I can't imagine that they did not ask, "Is the person that you saw Richard Allen?" to all the eyewitnesses. Like, maybe if they didn't do it with the first witness, okay, they didn't do it the second. I can't imagine a third witness not pointing him out, and the jurors didn't ask that question. I think for whatever reason, um one or both of the parties objected, and the judge just didn't allow the question, and if both parties agreed, which seeming as neither party asked the question, because look, I think if the prosecution asks, they're gonna give a wishy-washy answer, and the defense is better for the defense to just be like, none of them identified Richard Allen. They were all stood here in this courtroom instead of asking him, "Was it him?" And they're like, "I don't know. I can't tell. He kinda looks like him. He kinda doesn't." Like, the defense doesn't want that answer, and the prosecution surely doesn't want that answer. So it's possible, that there are other questions. Yes, Rex, it's a dangerous question. That other jurors asked that we haven't heard. It will become part of the record. A motion in Lemony about not identifying Richard Allen in court. There was a motion in Lemony about the, uh, sketches, the composite sketches, and the state said, "We are not calling these witnesses to do an in-court identification." But I don't know if there was something else that actually dealt with, like, just in-court identifications, but the state said ahead of time they were not calling witnesses as identification witnesses, but that doesn't mean the defense couldn't have asked the question because they described who they saw and, they could have asked it. They didn't for a reason. Um, Kay says, since Gull denied Andrea's motion and she can't request because she's not a party, does that mean Richard Allen's defense can request it? I I think that can they request it to be made to the public? I have to read the judge's response. She was I wondered if it had anything to do, and maybe she wouldn't write it right in there, with Andrea not being even a member of the public in Indiana. She doesn't live in Indiana because the media is not a party, right? And they get to petition the court uh, and ask to have access to the evidence. But I think the defense could ask for it. I just don't think that that is their focus right now. No one's gonna take even a unless they've got someone back in the office to file something, um, but I don't think it would do them any good. Judge knows what everybody wants, and no one's doing it. And Hoosier Girl asks about them pinging everyone nearby. They did. We just were told that it was so wide, it gets everybody in Delphi. Um, and Stephanie asked, when Richard Allen was arrested, did they have these witnesses come look at a lineup? Not as far as I know, but I don't know. They very well could have. I sorta suspect we would have heard that, like, in the Franks motion that all the witnesses came, um, and didn't identify him. So, all right, let's get to the last witness, guys. Let's get to the last witness. So they called Steve Mullen again. On September 24th, I guess that says 2022, Liggett called saying a person he located paperwork about Richard Allen from Dan Dulan. Mullen called Dulan and got his paperwork, and he pulled the DMV file. Maybe we'll find out his height here. Richard Allen had a 2006 Ford something and a 2016 Ford Focus. He obtained photos of Richard Allen's vehicle by going to the CVS parking lot and taking pictures. That's where Richard Allen worked. Um, he went to the Hoosier Harvest store. They put exhibits in of the pictures from the Hoosier Harvest store. They put in the Ford pictures of the Ford Focus at the CVS parking lot. Oh no, that must be CVS cameras. And then investigators were out at the Hoosier Harvest farm looking at video. Mullen looked from noon until 1 p.m. Vehicle came into frame edge of HHS on 300 North at 1:27 p.m. Okay, so you guys have to tell me in the chat because I'm sure Bob probably made a post or you guys have learned this from other people by now. They saying that Richard Allen's car came into focus at 1:23 p.m. But I'll keep going and then I'll look back. So then you have this thing where Baldwin wants to ask some preliminary questions as far as foundation goes. So he asks, "Did you see a vehicle that matched on the video?" Overruled. That's just your opinion. So he said that he believed it was a match. Okay, so the vehicle passes HHS at 1:27 and 34 seconds, traveling east to west on 300 North. So somebody tell me, 'cause I always forget which way is east toward the cemetery or toward if you're, like, in the middle towards the or is it towards the CPS building? Does anyone know? I know, never eat soggy Wheaties, I get that, I just forget which way on that road. Like, if I'm looking at the map, I would assume that that west is towards the CPS building, I just don't remember. Right, okay, so east is towards the cemetery. So and he parked at the CPS building, so that's him leaving. What? Why in the hell would the state put this on? Am I crazy? Wouldn't that be him leaving? S Wait, west is towards the CPS building. This said that his vehicle was going from east, to west. You said west is towards the CPS building. Alright, so that's him coming. Hmm. Or it's him leaving and he didn't park where they think he parked? Maybe he said the farm. Will you repeat that, please? Me? Okay. So what he said was his vehicle comes in the frame at the edge of HHS on 300 North at 1:27 p.m. The vehicle was traveling east to west. So from east to west, I should just say west to make it easier. It was traveling west on 300 North. So either he's if he were really parked at the CPS building, he would be coming. But he said he was parked at the Farm Bureau building. We have no idea where he really parked. Like, so if he was parked somewhere else, like, there was some woman who testified about a parking lot closer to the, um, sorta closer to the Mears entrance that I didn't see when I was there. I don't know if it's something that used to be there. If he parked down that way, then he would've hmm, then he coulda left that going that direction for whatever reason. Left going that direction. Alright, well, let's see what happened here. They do a close-up of the vehicle. Mullins approaches a map. He shows the vehicle pass HHS at 127:35. Do you believe the vehicle in the photo matches the description of Richard Allen's vehicle? This is the objection that she overruled? What? Do you believe? That's for the jury to decide. They're supposed to be watching the video deciding, is that Richard Allen's car? He gave them a picture of his car, let them watch the video. You don't put a witness on the stand that says, "I believe it to be his video," because it's not even like he's actually asking, "Do you believe?" Like, I mean, I guess if he would have said, "Did you see a car you believed was his?" And maybe that is the way he said it. I don't know. He said, "Yes." You can't see the license plate. You can't see the VIN number. What makes you think it's the same car? He says, "It's a hatchback." Hold on. Glasses. Alright. It's a hatchback. No. Yeah, hatchback, same shape, taillights, black sports rims that you can see daylight through. This is important because in the HHS video, you can see daylight through the rims. And he asks him, "What else?" Well, the time matched the time that Richard Allen told Dulan he was out at the bridge. I don't know what this question was, but it says the answer was October 13th. Mullen and Lizzet went to Allen's house, October 13th. Allen was advised that he was not being detained and did not need to come. He was not in cuffs. Allen agreed to go to the station. Allen drove with Mullen. Allen said he went to his mom's house that morning. He was off of work. Kathy was working. He got home around 11:30, got a jacket, went to the trails, got to the trails. He saw 3 girls and was looking at the stock ticker. He said he got to the trail at 12 o'clock and left at 1:30. So that's what he said in October. He went to the bridge. He walked to the first platform. Sounds like he saw the girls at the beginning of the trail head. He was coming in as they were leaving. He drove his 2016 Ford Focus. Allen said he came through the city on East Main Street on the county route past no, east on 200 North over to 700 North. Now, those of you know the area or want to look at maps, I'm going to say this again. He said he came through the city on East Main Street, or the county route, as they call it, I guess. East on 200 North over to 300 North. Sorry, guys, not 700, to 300 North. So from 200 North over to 300 North. He would have 300 North, and he would have come in on 300 North and would have passed HHS. He estimated he was there for an hour. And then what made him make a report? His wife told his wife that he was out there. So that's what they're saying, that's why Alan said he made the report, that he had told his wife he was out there, and his wife is like, "All right, well, you gotta let somebody know." Um, well, this is all new information. You guys all know all this? I don't know all this. He had on a skull cap, a black or blue Carhartt military style boots, jeans. One girl was older, seemed like she was babysitting. Got agitated at some point and left the interview. He was shown a picture of Bridge Guy and asked if that was him. If the picture was taken with the girl's camera, there's no way it's him. Now, this is in quotes. If the picture was taken with the girl's camera, there's no way it's him. Maybe that was his answer. If that picture was taken with the girl's camera, there's no way it was me. And then they got a warrant. They confirmed he owned the Focus in 2016, confirmed he bought it new in 2016. And that, my friends, was where they must have broke for the day or for the afternoon lunch. So, wow, that's a lot. That is a strange response. I agree. But if he's like, maybe it's not really that strange of a response, because it's like, well, I don't know where are you getting this picture you're trying to say is me. I mean, I guess the right response would have been like, no, or I can't tell from that. But how am I supposed? I can't tell who the hell that is. But he knows for sure as shit. If it was taken by the girls who are missing pictures, I never ran into them, so it's definitely not me. And I think by that point, actually, we know by that point they all knew that picture was, like, it was public knowledge. That I think that picture came from the phone, right, guys? Someone tell me if I'm wrong. So it's not that strange, actually. It's like, yeah, I would have liked to hear, like, I can't tell shit from that, but he's like, one thing I know for damn sure is, ugh, can't reading glasses. Oof, um, that if it was taken with the girl's camera, it wasn't me. So, all right, let's see if we got any new super stickers. No. Diz, man, these are all members questions over here. If they've got the little play button, does that make them a member? All right, let's do this. I had thought about 5 abrasions, penknife, 1 large blade pulled out horizontal, and another one. I mean, I don't know that the guys are talking about stuff from yesterday, I think. Okay, so when a witness is there to testify, is that person seated in a room, or do they get them from another room? So the way that it happens is, uh, typically the state has all their witnesses, like, in the prosecution's office, like, in different, not together, different areas, or maybe if together, they're like, well, they can be together outside, before they testify, and then someone comes out and gets them. But I think what they're doing here is, like, the next witness is sitting in the hall, so when that one's done, they come out. But you've got certain people that they decided last minute to allow in. There's some of the victims' families, looks like they're in there, that are also witnesses and were in there before they testified. They let, um, uh, Richard Allen's mom and wife in, and they're both witnesses. So, but generally, witnesses are not in the courtroom before they testify. It sounds like there's some times where it's like, well, this person's testimony is not going to be impacted by everyone else's testimony. Like, you're not going to change X, Y, or Z. So, depending on their testimony, it's like they're not going to be affected by this. So, they let them in. Um, this is what I want to know, Golden. Like, did any person pass the HHS on foot the entire the entire day, and did they start checking later? Did somebody check from midnight on until they found the bodies? Did somebody check, like, late in the day? Or they just checked till daylight, and I don't know if it's a type of camera, like, can you tell there's even movement, like, even if it doesn't get picked up? I don't know. I don't know. Allie, were Sarah Carball and Dan Dulan subject to recall as a witness? Are most witnesses being released? That's a question for Bob. I asked Bob that, I think, with Sarah. No, with Betsy Blair, because I was like, "What? There's a lot of stuff that," so I kept saying, he's like, "Well, they're gonna have to come." I'm like, "Okay, but did they release her subject to recall?" And he was like, you know what? I don't remember," because he was taking notes about other things, so he couldn't remember. Um, but he might know on the other 2. It sounds like, uh, from at least I listened to, Bob's description of Sarah. I don't even know they need to call her again. She made herself completely, she did worse for the prosecution than anything so far. It's bizarre why she'd do that, and why they're prepping their witnesses too much, making them look like even more unreliable than they are. But so, do you guys want me to review the motion to quash a subpoena, or has Bob done any motions? I know there's also a motion to reopen, um, to allow the Odin angle evidence back in. Yes, please. All right. So I'll pop it up. I'll pop it up. I'm assuming this came down today, so everybody's interested. And thank you, Dizzy and Mandy, or Dizzy. Confused about. I mean, this came to me from Dizzy. I just don't know if you guys do everything in tandem or what. But let me pull it up. Doesn't have your little stamp. You wanna send me one with your little stamp? Seeking justice. Follow Seeking Justice, everybody. Right? Uh, you know what? I'm just actually gonna pull up the email from the clerk, because it's not a picture, it'll be easier. Oh, I forgot. Hold on, guys. Give me 1 second. Oops. And Diz, if you can send me the other one that's, if you have it as a Word doc by any chance, otherwise I just have to open each picture separate, which is fine. I just didn't know if you happen to have it. Um, Whoops. Mm. All right. Motion 2. All right, I'm just gonna open this like this, and we'll switch between the 2. Share. Nope, sorry. Oh, you guys don't want that? Wrong screen. I wanna anger everyone, get everybody all riled up again. I don't think I can share that screen. All right, let me try to convert this into PDF real quick. Preview. Allie, I sent you the subpoena as a PDF. In a Oh, I thought that was the Odin motion. Sorry, thanks, Diz, I did see that. Alright, guys, bear with me, bear with me. Alright, because I saw here is the Odin one, so I assumed that was that. Alright, here we go. Got it, got it. Coming right at you with it. Share screen. I think this is it. Let's check. Yes, make it bigger. Alright. Okay, here we go. Comes now. Robert Ives, former prosecuting attorney by counsel Thomas J. O'Brien, pursuant to Trial Rule 45 of the Indiana Rules of Trial Procedure, and respectfully request the court quash a subpoena to testify in the above entitled cause. In support of said motion, counsel states as follows. He received a subpoena from the defense on October 22nd. The subpoena requests his testimony in the above entitled case. On October 28th, Richard M. Allen was charged with 4 counts of murder. Robert Ives' last day of being a prosecuting attorney for Carroll County was December 31st, 2017. Any information that Robert Ives would have had would clearly be work product, which is something not discoverable, nor is Robert Ives able to testify regarding any work product. Robert Ives is not a fact witness that should be required to prove an uh, undue hardship or an inability to obtain the information from another source. Uh, okay, so what they're saying is since he's not a fact witness, the only way to get him as basically an arm of the prosecution is to require the defense to prove undue hardship or inability to obtain the information from another source. Any information Robert Ives has would be purely speculative, irrelevant, and inadmissible in these proceedings. Robert Ives is requesting the court quash the subpoena for him to testify in the above entitled cause, or at a minimum, require the defense to clearly demonstrate the relevancy of Robert Ives' testimony, the inability to obtain the information from another source, and to demonstrate the work order protection. Demonstrate the work order protection. Oh, or for Robert Ives to demonstrate that he, like this is work product so that he doesn't have to testify. So what I suspect with this, one of two things. The the judge oh wait, sorry. S- Sharing random shit with y'all. um that the judge is going to ask probably in chambers like, all right, he's filed a motion, what is it that you're expecting to call him about, not all the details but the general gist, and then she'll probably either grant it, but I mean what I would normally expect is there to be an actual hearing on it to determine is the is he protected by work product, what is it that they want, and to see um if he can demonstrate that they need to call him. There's many things I think that they had sort of raised him about. Maybe some of you guys in the chat can remind me what, or Bob would know even better, like what is it from Robert Ives that they have brought up thus far that would um with uh what what they're looking for from him or what they've used him to establish so far. Um, so there's that. And then I'm assuming that you guys already see, they want his opinion about non-secular signatures. What's that mean? Okay, Delphi After Dark says, Ives has since changed his story and said he never said non-secular items when hundreds of people have heard him say it on a podcast. So basically, he was saying it was like ritualistic or religion based or some sort of Odinism type stuff. Is that what you're talking about? Because right, by saying something's non-secular, does that mean he at some point said stuff was secular or the lost opinions? Um, well, then I guess they feel strongly that they're gonna be able to get this. Okay, he was Delphi After Dark says, Ives was on, I believe, the Down the Hill podcast, and he said there were strange items left at the scene. He described them as non-secular items. Now he says he never said it. You mean like an object that might have been in a hand? I mean, I'm just saying, not to get everybody worked up on that angle again, but, um, hmm, items left at the scene that were non-secular. Huh. I mean, we've got no items, left at the scene other than the sticks and the F. Am I right? That were non-secular. So but isn't that again, I mean, she's not allowing that. It's like speculation, it's his opinion. I don't know. Like they've already said that I'm assuming, you guys tell me if I'm wrong, that the defense has already informed the judge pre-trial that this witness said those things, or is this new information that the defense has never presented to the judge yet? So, they did not establish, I don't think, I'm not there, but that they have not established yet who the bandana belonged to. Delphi After Dark says that's what he was referring to. That's me saying, like, the sticks and the R. We didn't find out about it until about a year ago. I was wondering, could that have been could she have had a cross in her hand and we got just a part of it, like a point of it, and that's what the shape was? I was thinking about that today, um, but I don't think there was any evidence that she had, like, any religious items on her. A Catholic cross would definitely be considered non-secular, uh, and not speculation. So, and I think obviously Sleuthie is saying that for that reason. She's like, that clearly wouldn't be considered would be considered non-secular and wouldn't be speculation if it was a cross. Um, yes, Tiff, I think everyone got that. Hopefully non-secular means religious. So, or I should have explained that because not everybody does know that. Allie, when do you advise a client to testify in their own defense? What would need to happen here that you would think would be a good idea for Richard Allen to testify? I can't imagine a good idea for Richard Allen to testify just because I don't know how he can explain what condition he was in or what, you know, when he made these confessions because he may not understand what condition he was in. Like I don't I don't see how, you know, I don't know. I don't think he can take the stand, but I don't know what they know. So, um but guys, has the has the defense already during pretrial informed the judge of Ives' statements on those podcasts, or are they something that has not yet been presented to her, even though it sounds like you guys have known about it? Like, was it in the Franks motion? Not the Franks, the Franks, I guess, or the third party motion or the third party evidence. Right. I agree with Emma. Let me read you guys again where he came through, how he got there. All right. He had the morning off work. Kathy was working. He got home because he visited his mom around 11:30 and got a jacket. He went to the trails. He got to the trailhead. Oh, wait. Okay, wait. He got to the trailhead. He saw 3 girls. He was looking at his stock tracker, said he got to the trail at 12 and left at 1:30, went out on bridge, walked to the first platform, and then Bob's notes say it sounds like he saw the girls at the beginning of the trailhead or I don't know if that was a question or that's Bob's notes. He was coming in when they were leaving. He drove his 2016 Ford Focus. He Alan said he came through the city on East Main Street or the county road or route. East on 200 North over to 300 North. He would have gone I don't know. Maybe Bob missed it. Almost looks like a frowny face. I don't know if it's a quote. Oh, he would have come in. Sorry, guys. He would have come in on 300 North and would have passed HHS. He estimated he was there for an hour. What made him make the report? His wife. He told his wife he was out there. So she told him to make the report. He was wearing a skull cap, black or blue Carhartt military style boots. So, and we haven't gotten across yet. Doesn't make any sense, Sleuthie says, that path. Why is cop hearsay not hearsay? Because it's a statement of a party, Richard Allen's statements. So his statements are allowed in. I think those girls got called, but I don't know if there's 2. Now, has everybody already gone over the the other new motion? Anything else new that was filed, or do I need to go over anything else? Because I gotta be back at y'all in, like, an hour on Mendez. Question, Jane H. When you described the bodies, I couldn't help think of yin and yang. The bodies were the opposite of each other. I don't know. I don't know. I didn't think about it. 3:30 Central. It's 2 o'clock almost, so an hour and a half. Let's see if we got any more super stickers. Here we go. Thank you, blessings galore. Allie, can an expert determine by examining the wounds if the perp was left or right-handed? Thanks. They can to a certain extent, but it's gonna depend on if they can also determine, are you standing in front of the person or behind the person when like, which way are you standing in relation to them? But typically, they can sometimes they can tell from, like, they know what the entry wound is, like, where it started, um, and, they can they can is the answer. But I'm sure there are certain, circumstances that could exist where they wouldn't. Um, alright, well, Dizzy says, "The Emmy said in this instance, he could not tell." Well, I mean, does anyone know if the defense has a pathologist on their list or a medical examiner on their witness list? Because of course not. Because I thought I remembered something was like from left, uh, from left to right, which would make you think they're well, yeah, it depends, I guess, what I I think that they can, uh, if they this testimony's already happened and the defense didn't really push on it, maybe they can't, and I don't know if they've got their own expert listed. There are things that he has confessed to that are untrue. There are also things the state claims he's confessed to that only he would know. Uh, and it seems like one of those things was started to get um, laid out yesterday. And I don't know, uh, and maybe I had to rewatch part of Bob's Live. I don't know if I fell asleep during some of it or if they got to this, but it sounded like the medical examiner all of a sudden, like, surprise testimony at trial said that he thought it could be a box cutter, and I don't know, is that something that came from Richard Allen that he said he used a box cutter? Does anyone know if these things are I didn't watch Vinny. That's the same thing, yeah, that's what I was thinking. Um, Dr. Vonda said, "Mouth wasn't moving. Had time to get across it, did bridge guy say down the hill?" I don't know. I didn't see it with my own eyes, but what's being described, the guy's mouth doesn't move, I mean, that's true. Thanks, Una. Um, so sorry, just got a text from my son. What's a fast time stamp? Allie, it was apparently in one of his confessions that he used as okay. So and again, like, the defense obviously has their own, like, plan, But for me, I would have been screaming and yelling surprise testimony if, because from what Bob reported, that the ME did not say anything about this in his, deposition. He didn't say anything about a box cutter in his reports, and am I wrong that it seemed like everyone's saying that the first time the defense heard the medical examiner pontificate that it could have been a box cutter and not um, serrated edged knife was on the stand? Because if so, I would have been screaming surprise testimony, like asking for a mistrial. I need time to get my own expert. Like the world would have been coming to an end if all of a sudden a medical examiner got on and said something that no one ever told me they were going to say. And maybe I'm misunderstanding what happened yesterday, but that's the impression that that I got. Um so, I don't know, were there sidebars? Were there like, I haven't had a chance to talk to Bob, like, I was busy till late, and then we did our morning thing, and he was already in the courtroom, and then I had that quick conversation, like, about this, so I didn't get a chance to ask him all of this, but Delphi After Dark is saying that Rick Allen, one of his confessions said that, so if that's the thing they're saying, that, "Oh, only the killer would know," but the medical examiner added it after Richard Allen confessed to it, if that's what's going on, that's some dirty, dirty gamesmanship. That's some dirty, dirty pool. Um, and I don't know. It doesn't seem like guys are telling me that I'm right, that it was. And then he said, like, it wasn't his professional opinion. Well, why in the hell are they letting speculation in? That is like that is the most. I'd be screaming mistrial from the rooftops if that's what, and most assuredly to then bar that part of the confession from coming in. That'd be my next motion. I want to bar the confession from coming in because the state put this guy on the stand with surprise testimony 1, with 2, pure speculation that they are gonna now it is so prejudicial because it makes it seem like he provided details that only the killer would know. Am I crazy? Because that is insane to me. What in the hell is going on over there? Wow, that's insane. That's insane. We all know what Gull will do, but you got to make the record. Like, file a motion for a mistrial. File a motion to bar the statements, that portion of his statement. Do not let that get into evidence. If that is true, if it is true that the first time that the defense knew that this witness was going to say those words was on the stand, that's a Brady violation. And that is highly prejudicial because there's no way in hell that the prosecution didn't know either. Like, oh, that's the first time we heard it, Your Honor. You didn't tell us this before. Like, that's not a thing. I'm just trying to read your guys' stuff to see um if I'm like completely off course like about this, but it's crazy. But I'm telling you, I do think that I do think, and I know we talked about it from somebody's comment earlier, that the defense, there's certain things the defense is letting them do to give them enough rope to hang themselves. But I also read in the comments, and I think I remember Bob saying, like, if it was, I don't remember if it was Baldwin or Rosie that cross-examined the medical examiner, that they were going into the fact that you didn't tell anybody. You didn't tell us this before. You didn't bother to tell um the defense about this. And if there's they this is not something that is like enough rope to hang themselves kind of thing. This is like something needs to get done. Like the motion needs to get filed. And where is Michael in here still? Because has he been following? Um, because that's crazy. That's crazy. If that's their whole thing about he said something that's real, that's outrageous. Only assuming that the first time that this guy ever said anything about a box cutter is after that statement, then What's the question? So if the Michael's asking me, what's the question? Okay. So it seems to me what we're all discussing right now is that the medical examiner testified yesterday, surprise testimony to the defense, that he has changed his opinion to believe that instead of a serrated knife that was from a box cutter and it was from part of the box cutter, and then on cross he admitted, well, that's like speculation, not fact. If that is the case, and that is what the state is using these confessions to say only the killer would know these details, and they're gonna try to pair that, even if they don't make that argument, that's being paired with this guy getting on bullshit speculation that he's never said in a report before and wasn't disclosed, it sounds like, pre-trial, unless I'm completely wrong, that's, like, that they need to file a motion to bar that portion of Richard Allen's statement, not to allow any statement that includes reference to a box cutter in, or for a mistrial, and or for a Brady violation. Is there any world under Indiana, um, the Indiana rules, Michael, that they wouldn't have to disclose the medical examiner changing his opinion before he gets on the stand? Well, he says, "Of course, I'm right about it all." It's a might be too late now. Why it just happened yesterday. They haven't put in, unless they're doing it right this second, they haven't put, oh, is that where we ended off? With them putting in his confessions? No, no. Why might it be too late now, Michael? Oh, no, probably not. Is that me you're answering, or which? Alright, we'll have to, but no objection to testimony, no sidebar. Hmm. Well, I feel like you can kind of, uh, I'll tell you people, it's really hard, okay? Like when you're on trial and things come at you, you're trying to realize what was just said, how you're going to react now. And sometimes you forget to object, you know, and to demand a sidebar right then and there. And then you get completely screwed because it's form over substance. So I'm here thinking, all right, well, there's a way, like, well, if they file a motion, they can kind of overcome the objection by saying, you know, I mean, damn it, one of the other lawyers files it and says it was ineffective assistance for their co-counsel to have not objected or something. Um, no, probably not to the Brady question. When we say no, probably not to the Brady question, as to it's not a Brady violation, or it's not too late to raise as a Brady violation, or let's see, these folks are pretty weak on objections. Oh, they may have a plan. That's what I was saying earlier, that they may have a plan, but this is not one. And I mean, shit, they may have something I really don't know, and it is all part of the plan. But it sounds like, from what I'm hearing, the defense, whichever one of them handled the cross, was getting upset about this. So it doesn't sound like this was part of a plan they already knew was coming. And yes, everyone, Judge Gold will likely deny it's not a Brady violation. Hmm. Why? Or a or a discovery violation, I guess, is what I meant to say, not a Brady violation, a discovery violation. Is Core, is that who I'm talking about? Is that the same? I don't know, I can't keep up. The medical examiner? Maybe a discovery violation. Yeah, that's what I meant, sorry, not a Brady violation, because it's not exculpatory or favorable. And I don't know uh, what Indiana's discovery rules are, but a discovery violation like that, no, you have to disclose that. This was surprise, it was not disclosed. They need to do any number of things. They need to now get a new expert. They need to exclude Richard Allen's if the guy said it's pure speculation, then they need to exclude that portion of Richard Allen's confession or statement when they put in the statements because that's extremely prejudicial. Crazy. Crazy. All right. Let me see if we have any new super stickers. Oh, thanks, Czar. Or thanks, Una, for your czar. Uh, so appreciative of the hard work. You might have said that already. I might have done this okay already, but that's okay. That's okay. And I think there were some super stickers in the beginning that I might not have, if they weren't questioned. Paula Woolsey, thank you. Thank you very much. Appreciate it. And Deaf Otter, YouTube member, thank you. Bob would give you a family hug. Lana, thanks. I might have mentioned this one already. Allie, for showing us just how hard y'all's job is. Kathy Simmons, thank you. Thank you. And I think we got the rest of them. So do we break until the Menendez, or is there another motion that Bob has not gone over? I know we talked about the Odin thing. He has sent it to me. I don't even know how long it is yet. But is that something that we need to oh, no, maybe he didn't. Oh, wait, he did send it to me. I don't know, it didn't come through. It's got a question mark. Oh, it was yesterday? Oh, boy, she sent it yesterday. Bob's notes. Yes, let's discuss. All right, let's do it then. All right, that's me. Gotta find it from yesterday. She probably just resent it because that's how great they are. Wait, Bob's out. Okay. Let's go over it. All right, she did send it. So let's pull it up and I'll share it with you guys. Thank you, Dizzy. Make it bigger. Wants me to use AI assist. No and no. Thank you. Not today. You and your AI. All right. See how it looks. I can make it a little bigger. Okay. Ah, it's short. Yay. Motion to admit evidence of Odinism, North paganism, ritualistic killing. All right. Comes now the accused Richard Allen buying through counsel and moves to admit certain evidence that this court has thus far prevented the defense from presenting to the jury pursuant to its September 4th order. The defense states as following. On October 22nd, 2024, CSI Brian, I know Bob told me how to pronounce this, but I don't know, so I'm still going to say Olhe, testified concerning various aspects of the crime scene. Somebody asked a question about how the door might be open. This looks like what we're getting into right now. During his testimony, CSI Olhe indicated that the sticks covering the girls was an attempt by the killer to conceal the girls' bodies. Yes, that does open the door for an alternate theory. All right. On September 18th, 2023, the defense filed its first Franks memorandum in which the defense laid out in painstaking detail the various pieces of evidence that provide support for the theory that the crime scene contains various signatures related to Odinism/North paganism. On October 1st, 2024, the defense provided the testimony of Dr. Dawn Perlmutter to the court. Dr. Perlmutter provided her CV and testimony at hearing. Dr. Perlmutter's experience, including, among other things, training the FBI and other local, state, and federal law enforcement agencies concerning how to identify a ritualistic crime scene, and literally writing the book on ritualistic crime scene identification used by local, state, and federal law enforcement. And the judge really didn't care about those credentials. I find them pretty impressive. After reviewing the crime scene photographs and other reports and documentation, Dr. Perlmutter's testimony included her assessment that the sticks on the bodies, F-tree, and other aspects of the crime scene were textbook signs of a ritualistic murder related to Odinism, North paganism, including using sticks and blood on the tree to form runes and bind runes. I just wish we said something more like had textbook, signs of someone with familiarity with Odinism or North paganism, or signs of, uh, you know, intentionally placed sticks and blood on tree to form runes or other, for example, non-secular, uh, you know, or just blatantly like that is completely independent, wholly independent of concealment, and that they are designs without necessarily calling it um, textbook signs of a ritualistic murder. Dr. Perlmutter's belief did not come out of left field as law enforcement began investigating the Odinism/North paganism angle as early as 2 days after the girls were found, and law enforcement continued to investigate the Odin/North paganism angle until the death of law enforcement officer Greg Ferenczi in 2021. The state of Indiana has provided its explanation of what the sticks represent: concealment of the bodies. And Richard Allen has a Sixth Amendment right to offer the jury his alternative theory as to the reason the sticks are aligned and arranged in the manner in which they are arranged. I wholeheartedly agree. Absolutely. Denial of this opportunity to present the jury an alternative explanation would leave the jury with only one explanation: the explanation provided by the state of Indiana. Additionally, the sticks on the girls appear to be arranged, there you go, in a pattern/arrangement, or at a minimum, using a person's own eyeballs. Common sense, logic, and reason could cause a reasonable person to believe the sticks were formed into some pattern/arrangement and weren't being used to conceal the bodies. Therefore, it could or would be confusing to a juror who might think that the arrangement of sticks was intentionally placed, or a certain arrangement of the bodies, but that those jurors aren't being provided with any explanation for the way the sticks are placed on the bodies in a certain arrangement. Now, I'm just going to say, these are the words I wish were above, that we now want to put in evidence, our evidence, to demonstrate that the arrangement of sticks was intentional and placed in a certain arrangement on the bodies, and that that person had knowledge of Norse paganism or Odinism, whatever. Okay, so 12. Evidence of Norse paganism/Odinism would therefore assist the trier of fact and alleviate confusion for the juries. Now, that's a good statement right there. Additionally, it has been learned at the August 1st, 2024 hearing that the blood found on the F tree resulted in the state of Indiana retaining a blood spatter expert more than 7 years after the murder. Dr. Perlmutter's testimony would be offered in part to counter the testimony that the state's blood spatter expert and the accused has a Sixth Amendment right to counter their blood spatter expert's testimony. That is also true. What did they put someone, did someone already testify about, was their blood spatter expert already called? Being able to provide evidence to the jury that Odinism/North paganism as an alternative explanation for the stick arrangement on the girl's body, including the testimony of Dr. Perlmutter, would offer the following: a rebuttal to the state of Indiana's explanation of why the sticks appear the way they appear, consistent with the Sixth and 14th Amendment of the United States Constitution, Always throw in the Indiana Constitution, please. B, a rebuttal as to the state of Indiana's blood spatter expert. C, an alternative explanation to any confused juror who believes the sticks and blood on the tree weren't used for concealing the bodies, but rather believe that the sticks were arranged by a Norse paganist slash Odinist as part of a ritual. That's the part you don't need as part of a ritual. That's the part you gave yourself this little extra part that you don't have to prove. All you want to prove is that these sticks were arranged, that blood marking was intentional. No matter if it's Norse paganism, Odinism, or somebody who just likes to make little tiny weird shapes on a body, and these little tiny weird shapes look like someone was trying to, uh, create something, uh, that means something in Norse paganism, but it doesn't have to be part of a ritual for that. It can have, like, ritualistic elements and not be part of a ritual. Like it's the same thing like Sleuthy was saying. Like if you have a super religious serial killer and that person is believing that this is God's, like he sent God gave him this task to go and kill certain people. And if you drew a cross or left a crucifix, would that make it a ritual? Or would it make it someone who who has strong Catholic or Christian beliefs, someone who believes he's been motivated by God to do what he's doing? I mean, it's the same thing. Why use the word ritual? Defendant files this motion currently as in part for the purposes of a ruling in anticipation of the need to contact our witnesses in the event the court reverses its ruling. So there you go. Oh, let's see. Got any new questions from this? Um, I enjoyed the chat, but it's too fast. Can you put it on slow-mo? Thank you, Buffy. And uh, I think the mods try to keep up on that, so I haven't been following it. And thank you, Who's Your Girl? So I don't know. To me, I think their motion has merit. I do think that the state putting in their reason, calling it concealment, does open the door for an alternative explanation. I just don't know if that alternative explanation has to go as far as calling it a ritual, as opposed to someone who is knowledgeable about this information, made these designs. Um, all right, let's see what we got. How fast will Gull deny the motion? I don't know. Probably pretty fast. Probably pretty fast, but they need to make a record. That's why, like, you can't forget to object at trial, and you can't forget to ask for a mistrial right when it happens, and, like, there are certain things, yeah, you c okay, I'm gonna give them the rope, and I'm gonna let them hang themselves, and that could be their strategy, but there's other things that you must object to preserve the record, and when you don't, all is lost. Um, so alright, guys, well, I think we are good. Um Bob will be at you later. I'm coming back at you. I don't know if our thing is set for 3:30 or um on the Menendez presser, but no, it right now it is just a motion. Jojo asked, did they approve the Odinism to be discussed at trial? No, they filed a new motion. Um, Allie, look at my sticker. They filed a new motion requesting. Oh, there's another sticker. Oh, Allie, I emailed Bob the alphabet decoder, I believe, has the little R, and I can't see what the heck that is, not even if I had glasses on, along with the stick placement and intentional blood markings. 214 is related to Odin's son and older sacrifices. Huh. I was asking yesterday if 213 had any meaning because they were taken on 213 at 2:13 PM on February 13th at 2:13 PM. So, thanks, Kraken, and thank you for your $10. Bob's little alphabet decoder. Thanks, Michael. Thanks, everybody. And please, 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 let me just check y'all right now. That's what I'm gonna do. Check y'all and check this out. How many likes do we have? How many thumbs up do we have? Um 711. Oh, come on, guys. There were like 1,600 people here. All right. Of the 1,200 left, those who didn't, please, please, please give a thumbs up. Get this out there. People don't even know we're doing this in the afternoon. We're giving all the morning and afternoon, um, right from inside the courtroom, right from Bob, boots on the ground. In there, we get his notes. I bring it to you and you guys get a little primer. And yes, I will be back at 3:25 Central Time, so 1 hour for the Menendez presser about I guess about uh whether they're going to be sentenced. And thank you mods for um all your hard work and all of our members and everybody else. I will thank you even more when we get the thumbs up. Just kidding. I still love you guys no matter what. Don't worry about it. And I will see you soon. Bye, guys.